So the answer is more freedom, more individual choice. Allow people to make their own decisions in their own minds. It is not a panacea. It is not a utopia, but it is the best of all possible worlds. Thank you. Be happy to answer any questions.
Pass out for the questions and answers. There's a back of the room moving forward. And who's going to be reading the first one? Oh, there he is right there.
What do you think will happen if the Supreme Court throws out the mandate clause but does not eliminate the entire law?
Okay, so the question is, what if they only strike down just the individual mandate provision? Now, as you know, one of the arguments is, should they strike down the entire thing or just part of it? I'm pretty confident after hearing the argument, that they'll strike down the whole thing or nothing. And the reason for that is it's kind of a complicated issue. It's not really a right-wing, left-wing thing. If you think about it, suppose that you're going to strike down just one portion of the law. Now you're going to be left with a statute that nobody passed. Nobody in Congress voted for it, right? You're left with, if you have A, B, C, and D, and you take out C, nobody in Congress voted for just A, B, and D, right? So, and especially in this case, one point I think is interesting is not only would Congress not have passed this law without the mandate, but they could not have passed this law without the mandate. Because the election of Scott Walker meant that Congress couldn't go back and do a redo. Remember that? After Walker was elected, they had to stick with the bill they had because they didn't have the votes necessary to do it over again. And the version they had passed at that point had the mandate in it. So not only would Congress not have chosen to pass the law without the mandate, but they couldn't have done so. And I think that the justices are not going to want to intrude on the democratic process more than they have to. They're going to say, our job is just to say whether it's constitutional or not. Strike down the whole thing or nothing. Especially because, but it's not an easy point, right? I mean, it's not an easy argument to make, because there are lots of things in the statute that have nothing to do with the individual mandate. The reauthorization of the Black Lung Coal Disease Act of 1945, or whatever, right? Has nothing to do with the individual mandate. Why should that be struck down if everybody would have passed that anyway? I think the answer has to be that the burden should be on Congress. If this law falls, it's their fault. It's not the courts. It's they who chose to take perfectly good provisions and add an unconstitutional element to them. So I think that the court will strike down the whole thing or nothing. Yes?
What if they don't?
Well, I think the only other alternative is they'll strike down the mandate and the guaranteed issue provision of the statute, in which case Congress will have to get together again and write something else. And no offense to my Republican friends, but I don't trust you Republican congressmen to write a good free market bill. The Republican Party has not been pro-free market then, and it's not pro-free market now. We know that because Romney is your nominee. Next.
Candidate Kagan, who's relentless in oral arguments for government control. How can she be reformed? Why doesn't she like Israel?
And who is this?
Kagan.
Kagan. Well, you know, first of all, she's a new justice. And new justices never get a word in edgeways. Because the rule is, you know, in these oral arguments, what happens is you stand up there, you're arguing, and they interrupt you all the time with questions. And the senior justice prevails. So if the chief speaks at the same time as Kagan, the chief gets to talk. So poor Kagan hardly ever gets to ask a question. But you know, she's a Harvard liberal who's never been outside of legal academia or government service in her life. So she doesn't know the basic principles of how you run a business, how you provide jobs for families, how you provide a product or service when customers can shop elsewhere. She's never experienced that. So, you know, it's no surprise that she's pro-government. And I guess that's all. Yeah.
Have you read all 2,000 plus pages of Obamacare? And what are some of the lesser known?
I have not read the entire statute, which I think qualifies me for Congress.
Doesn't the lack of a severability clause insist that if the Supreme Court strikes the individual mandate, then the whole law will be struck down?
Well, that's another part of the severability argument, whether to strike the whole thing down or just part of it. It's true that the bill does not include a severability clause, but that really isn't the end of the question. Lots of statutes don't include severability clauses, and it's up to the judges to decide whether a statute is severable or not. A severability clause is only a suggestion. So even if there had been a severability clause, that would not necessarily mean anything. Now, it's true that the Congress chose not to put one in, and as I said, they could not have passed a statute without the mandate. And there's all these things, the Cornhusker kickback and the Louisiana purchase and all this corrupt buying off of votes that went on. And so I think the statute really has to rise and fall as a whole, regardless of whether there's a severability clause or not.
If they don't, can't Congress still repeal it? I would think they would, right?
Can Congress still repeal a statute? Well, of course they can. But remember I mentioned that IPAB, the Independent Payment Advisory Board, that part of the statute is made unrepealable. So what's going on in that case, that's a case that my wife is litigating on behalf of the Goldwater Institute in Phoenix, Arizona. And that case, the federal government's lawyers wrote up a stipulation saying, we promise it can be repealed. Now here's a new question. Can they do that? If a statute says it can't be repealed, can the president's lawyers say that it can and be bound to that? Nobody knows. It's never been done before. None of this has ever been done before. It's open season. It's make it up as you go along. Constitutionalism. It is a blank slate, and that's how the Obama administration sees the Constitution.
This is off Obamacare.
Good.
What about giving up our sovereignty through United Nations treaties? Like the law of the sea, for example.
I don't know anything about the law of the sea treaty. It's been one of those things that keeps popping up on Facebook, but I just don't have time for it. With regard to national sovereignty, I will say there's a very interesting case that's going up to the Supreme Court pretty soon called Bond versus United States. You should keep an eye on it. And it's interesting because it involves the question of whether Congress can increase its own powers through the treaty power. As you know, the Constitution says treaties are the supreme law of the land. There's a case called Missouri versus Holland. It's like 80 years old. Where the court said, if Congress agrees to a treaty, and that treaty requires A, B, and C, then Congress can do whatever it needs to do to make A, B, and C happen, even if it's not in the Constitution. Now that's a real problem. What happened in the Bond case, the Supreme Court has already heard this case. You may have heard about it last year. This is the case about the woman who tried to kill her husband's girlfriend by poisoning her mailbox. Did you see this? It's a great story. I love constitutional law. This woman found out her husband was cheating on her, so she went and she got some chemical poison, and she painted the woman's mailbox and doorknob with this chemical poison, hoping the woman would touch it, it would get on her skin, and she'd die. Didn't happen, but the woman found out about it and called the cops, and then the woman who did it was brought up on charges and went up to the Supreme Court because she was charged under a federal law that prohibits the use of certain kinds of poisons. And she argued, well, the 10th Amendment really leaves this matter to state power, doesn't it? I mean, there's nothing in the Constitution that says Congress can regulate poisons. And the question before the court last year was whether she's even allowed to make 10th Amendment arguments. And they said, yes, she is. So the case went back. Now it's coming back up, and the question is, this prohibition on this poison is done through the treaty power, because there's a treaty we signed. And the question is, does that allow Congress to expand its own powers? Could Congress pass a law, sign on to a treaty that gives it power to do something that the Constitution doesn't allow it to do, and make that into something the federal government is allowed to do? So if you're interested in international issues and how they affect federal sovereignty, and especially state sovereignty, that's a case to pay attention to. Next.
Didn't Reagan sign into law emergency room for the indigenous? How does this factor into the Supreme Court decision?
I'm so glad you mentioned that. I forgot to mention that. That is an issue that is very important in the last day's argument about Medicare, right? So Medicare, this thing about whether the federal government can say to the states, you have to expand Medicare eligibility. The theory that the courts have used is they've always said, look, it's just a contract between the states and the federal government. The federal government can't force states to do stuff, but it can offer them money and say, we'll give you $20 billion if you will expand your Medicare, or whatever, right? So they say it's just a contract. And the states don't have to accept the money if they don't like it. That's been the rationale. But in this case, that's not really true. If the states were to say today, you know what, we don't like this whole Medicare scheme, we want to go back to the day when we provided at the state level for the indigent who were sick or injured. For example, Arizona, it had a state-run program for taking care of sick people who were too poor to pay their doctor's bills. Could the state, at this point today, say, you know what, this is just too much hassle to deal with the federal government, we don't want to participate in Medicare anymore. We'll run our own program? No, they can't. Because passage of that statute, the statute EMTALA it's called, the Emergency Medical Treatment Something or Other Act, that law makes it a crime to transfer a patient from one hospital to another on the grounds that they can't pay for their care. If Arizona or California or any other state were to try and reestablish its own state-run hospital for the poor, it would have to transfer people from hospitals into that hospital, which is a federal crime. So the states are not allowed to refuse to participate in Medicare anymore because it's a federal crime. That's all the more reason to say that what's going on with the Medicare part of this law is just too much. It's not a bargain between the states and the federal government. It's federal arm twisting of state power.
What is the most horrendous example of eminent domain use or proposed use pertaining to the high-speed rail authority?
I don't know about the high-speed rail authority specifically. Obviously, they're going to use eminent domain for that, and obviously there's nothing you can do about it. Not only, we all know about the Kelo case, in which the Supreme Court said the government can take private property from one person and give it to another on the grounds that it's somehow good for the economy. That case didn't have anything to do with railroads. And if anything, railroads have had, for 150 years, far more power to use eminent domain to build their tracks than anybody else has. Railroads are responsible for this problem. They created this problem. They started doing this in 1820. And some of us aren't quite old enough even to remember that. So I think and California state law is even worse when it comes to eminent domain. You might remember Proposition 99 a few years ago, which was supposed to protect us from eminent domain, which actually increased the state's power of eminent domain. California is the only state in the nation to have, by popular ballot initiative, actually increased its eminent domain powers after Kelo. Now, I think it's safe to say that nobody who voted for Proposition 99 thought that's what they were doing. But that's because they were lied to. The statute, that statute was written, or the constitutional amendment, that constitutional amendment was written by the California League of Cities, which is the people, they're the triangle trade, they're the robber barons who benefit from the abuse of eminent domain power. And what they did was they said, we promise not to take owner-occupied homes. That's it. That's all that it provides. Protection from owner-occupied homes. That means you have to have lived in it for a year at least. It doesn't apply to apartments, which are usually lived in by the kind of people who can't afford lawyers to protect them from eminent domain cases. It also doesn't apply to the most common victim of eminent domain abuse, small businesses. It doesn't apply to farms. It doesn't apply to churches. It doesn't apply to vacant land. It doesn't apply to your vacation home, your second home, your investment home. It only applies to owner-occupied residences, and it doesn't even apply then if the project in question is a public-private partnership. Now, I don't know about Mountain View, but I'm from Southern California, and not far from where I grew up, there's a place called Victoria Gardens. It's an open-air shopping mall, and it's got a Victoria's Secret and a Subway, and like every other one has, right? It's all Bed Bath and Beyond, and a post office. Now it's a public-private project, and now they can use eminent domain to take even owner-occupied homes under Prop 99. You were lied to if you voted for that initiative. I tried to warn you, but you didn't listen. So California is even worse when it comes to eminent domain, and there's absolutely nothing you can do about it if the high-speed rail decides to take your property. I simply will not take those cases. I'm sorry, and I'm one of the few people in California that cares about protecting private property rights. So. Yes? Isn't this a cheerful conversation? By the way, Scott Walker, yay! Actually, I'll share in a little bit of that glory by saying that there's a case that's going to be decided by the Supreme Court, probably, almost certainly going to be decided on Monday, that you should all keep an eye out for, called Knox versus SEIU. This is a case, yeah, it's not that good. I did a brief in this case, and what it's about is, this is one of, there's so many of these cases, but you know how unions can force you to pay them? Even if you don't join the union, they can impose these agency fees. And the Supreme Court has always said, unions can force people to pay agency fees to the unions. The only industry in the world that has the power to tax people directly. So that's okay with the Supreme Court. But the court has said, but the unions can't use the money for political campaigns. And of course the unions solemnly pledge that they will never use the money for political campaigns, right? What it actually says is, if they do use the money for political campaigns, and you don't want to support that political campaign, you have the right to object and get your money back. That portion of your money that's spent on political campaigns. Now, of course, since the unions refuse to submit to accounting, they claim that 95% of the agency fees are spent on non-political activities, of course. Yes. So, of course, if you're, let's take my mother, for instance. My mother worked as a school librarian in the Rialto Unified School District in Southern California. She refused to join the union because she's a Rockridge Republican. And she drew attention to herself one time when she told her fellow workers that she would be crossing their picket line if they went out protesting. And she refused to join the union. So she's entitled to 5 cents on the dollar of every dollar that they take from her, right? And you have to be pretty crazy to go through all the trouble and expense of drawing attention to yourself and hiring a lawyer sometimes, filling out forms in triplicate every single year to get your 5 cents on the dollar back from the union, your $20 a month that you're required to pay the unions. But what's interesting is, the Supreme Court has said, dissent is not to be presumed. What that means is, if you're like my mother and you don't want to contribute to the union political campaign, it's your responsibility to file an objection. You have to file the objection and you have to sue if they don't give you your money. Now, why does that make sense? What other realm in all of American law do we presume that people are willing to give up their constitutional rights? What other realm of constitutional law do we say, if your right to freedom of speech can be taken away from you simply because you didn't do anything? When do we ever say that inaction is enough to waive the First Amendment? So in my brief, I urge the court to change that and say that we will presume dissent, like we do in everything else. Force the union to ask first. That's all, right? Of course, the union take that. But during the oral argument, Justice Kennedy leaned forward and said, why don't we just force the unions to ask first under the First Amendment? So I'm really looking forward to Monday. I got to see what the court said. Maybe there's going to be nothing, but, it could be something exciting. Citizenship means reasoning with people. Being a fellow citizen means that you agree on certain fundamental principles. You can disagree around the margins, you can disagree about who should be dog catcher, but you share a fundamental agreement about certain basic principles. As Americans, those fundamental principles appear in the nation's foremost law, in the most fundamental law that we have. Do you know what that is? It appears in Volume 1, Page 1 of the Statutes of the United States. Anybody? It's the Declaration of Independence. The Declaration of Independence says, what are the shared values of American citizens? Those shared values are, all men are created equal, and they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Whenever government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government, organizing its powers in such form and laying its foundations on such principles as shall seem to them most likely to affect their safety and happiness. Right? We agree fundamentally that all people have rights that are not privileges from the government. They have basic rights as free people. They get together to create a government to protect their rights, nothing more. And if government doesn't respect that, we have the right to change that government. Prudence indeed would dictate that governments long established should not be changed with light and transient causes. And accordingly, all experience has shown that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses pursuing invariably the same object evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and seek future safeguards for their safety and happiness. That's what we agree on as American citizens. That's what makes us citizens. It's what makes us a nation. We're not grouped together by racial or tribal history. We're grouped together by our agreement to these principles. And increasingly, you find people who don't believe or don't know these principles, who openly disagree with them. Howard Zinn, the historian whose book was assigned reading to me when I was in community college, says that the Declaration of Independence only applied to white men. Justice Thurgood Marshall, not to mention Chief Justice Roger Taney, agreed. As Lincoln said, you would have a hard time explaining to a child the basic principles of geometry if you denied the axioms on which those principles are based. And once you accept those axioms, then you can understand geometry. The principles of the Declaration of Independence are the fundamental axioms of a free society. And yet increasingly we find people who don't know, aren't familiar with, don't care, don't believe in them. They think whatever they want, they have a right to. And they have the right to make you pay for it. And they're unwilling even to listen to an argument on these points. Now, the right wing is just as much at fault as the left wing on this position. Just as often I hear conservatives say exactly the same thing about liberals. There's no reasoning with those people. They're beyond the reach of reason. If it's really beyond the reach of reason, there's only one thing to do with that person, and that's kill them. You cannot get along with a person you cannot really reason with. You can only kill that person. If you really believe you cannot reason with your fellow citizen, then you are not fellow citizens. What keeps me up at night sometimes is the fear that there's an increasing tendency among citizens not to discuss things in terms of rationality, in terms of logic, and shared history, the experiences that we went through with slavery and the Civil War, the Civil Rights Movement, with World War II and the fight against fascism, and the Cold War and the fight against communism. A lot of people don't know this stuff because of public schools, and don't care because they're busy watching American Idol. Nothing against American Idol, but if that's all you care about, then you're part of the problem. Right? And I explained this all to my friend Andrew, and I said, you know, it terrifies me that if we keep going down this road of deepening political and social division, what's going to happen to this country? And he said to me something that has really stuck with me. 10 years later, he said, no generation is more than 20 years away from a civil war. It just somehow never happens, or rarely. And the reason why is because in the end, there's some part of all of us that still does believe in the principles of the Declaration, that still does believe in the fundamental principles upon which this nation was built, that believes that liberty is something not to be taken away in order to provide services or products to people who want them, who understand that individual gumption matters, who understand that nobody can be trusted to govern our lives or make our decisions for us. It's something deeply embedded in the American character that the left really hates. It drives them crazy that people still believe this stuff after all these years, after all the professors have told them, after all we've taught them about social justice, after all the times we've told them that Americans are undertaxed. They insist on believing in their silly notions of individual autonomy and freedom of choice. Why? That's ridiculous, right? There's a passage in George Orwell's 1984 when Winston Smith looks out the window and he sees the washerwomen in the streets. And he says to himself, if revolution ever comes, if liberty is ever to revive, it will come from the washerwomen. It will come from the proletarians. It will come from the average common people. That's who it came from last time. That's who wrote the Declaration of Independence and fought for liberty. That's who freed the slaves and wrote the 14th Amendment. I said earlier the Constitution of the United States was written for people of ordinary understanding. People who can understand the doctrines of Thomas Jefferson, who can understand the doctrines of the Federalist Papers. Yeah, language is a little antiquated, but all of you can read it. You can all read great books about the Constitution, like Kelo book, The Bill of Rights, or his other book, America's Constitution and Biography. Fantastic books about the Constitution of the United States. You can all understand these principles, and you can all teach them to your friends and your neighbors and your children and your children's children. And that's the only thing that's going to make a difference. I was asked earlier, what do we do? What are we going to do? And the answer is politics is not going to solve this problem. Lawsuits aren't going to solve this problem. They're great fun. They're worth doing. I love them. The reason I do law is because I hate politics. Because in politics, it's just whatever's popular. In law, at least they'll tell you what it is they got wrong. When they rule against you, they'll write an opinion that says, here's what we believe, and you can point you, that's where they're wrong. But even lawsuits aren't going to change everything and make everything perfect from now on. It's a constant struggle. Ronald Reagan said, we stand here on the only island of freedom that is left in the world. We defend freedom here, or it is gone. And if we fail here, we will have to tell our children and our children's children what it was we found more precious than freedom. Thank you very much. I'm going to stick around. I can answer any other questions.